cybersecurity, and perhaps more importantly, the people joining from other time zones later today. Professor Wolff, thank you so much for joining our Hack From Home against COVID-19 weekend. It's been a really exciting, almost 2 days now, 1.5 days. We've had teams from all over the world collaborating to create applications that could stop the spread and social effects of COVID-19, but a crucial but also manage to protect and uphold people's privacy and civil liberties at the same time, which is something we very much want to emphasize in this time of crisis. Had a great load of expert speakers, including VCs, anthropologists, economists, ethicists, and various senior professionals, and you are our latest, so thank you so much for agreeing to talk. I was delighted that we persuaded you to have you with us, particularly after reading for some time all your pieces in the New York Times and other publications, including that strong one you made about privacy. So it's a pleasure to have you here, and I cede the floor to you.
Thank you so much for having me. I'm really excited to be here. I'm really excited about all the amazing work that you all are doing towards trying to build technology that can help us during these very strange and scary times. I do cybersecurity and digital privacy policy work. So what I'm going to talk about today is a little bit of law and policy, and then a few examples from around the world of how different countries, how different governments have been thinking about trying to use data, especially location data, though also some other kinds of data, to help track the spread of coronavirus, to alert people who may be especially at risk, to enforce quarantines, and sort of what some of the different approaches we've seen have been, just to get you thinking a little bit about this as you're building your own ideas into what are some of the ways in which location data in particular has been a tricky area for law and policy, and how has that manifested just in the past few weeks and months as different governments have been scrambling to find ways to deal with this crisis. And one thing I would say is we're seeing, understandably, a lot of places relax some of the protections around privacy that would typically apply. And I think, there are justifiable reasons for doing that right now. But I also think that when you do something like that, you have to do it very much with an eye to why are we doing this? How long will it last? What will the sort of long-term consequences or unintended consequences be of making these changes? And how do we make sure that they're sort of as limited and as specific to the purpose we're trying to fill as possible? And so again, I'm going to start just by talking a little bit about the policy landscape, particularly with regard to US law over location data. And then I'm going to shift and just speak briefly about some of the different ways that we've seen countries using location data. This certainly won't take an hour, and I'm happy to take questions either at the end or throughout if folks are interested in any of this. So to start, I would just highlight there are a lot of different kind of bits of data being collected by mobile phones by a whole bunch of different parties. So this is a chart that comes from a Citizen Lab report called The Many Identifiers in Our Pockets that thinks about sort of what are some of these different identifiers, and also who are all of the different parties who are collecting them, from your cellular provider to the Wi-Fi provider, the operating system vendor, the application developers. And for many of you, this is probably very familiar information, but when I say teach policy students about the protections around location data and metadata, this is often a little bit surprising that there are so many different pieces of metadata being collected by all of these different systems and shared with so many different providers of different services, from the cellular network to the individual applications. And when we talk about kind of protecting privacy, in particular protecting the privacy of what I'm going to call metadata, which is going to be everything that's not sort of the content of your emails or your messages, that is really pretty clearly protected in a lot of countries under various privacy regimes. This sort of more peripheral metadata material often has much less strong protections because it's not viewed as being actually sort of the contents of your conversations, the meat of your communications in the same way. And because of that, there's also a lot of uncertainty in many places about whether it's protected, how strongly it's protected, who can use it, and when. And that leads to a lot of disputes in law, and it also leads to a lot of freedom to sort of use this information more liberally than we might say use the contents of your email, which again, we would understand in most countries is something that if the government wanted to access, they would have to go get a warrant, or there would have to be some sort of clear steps in place for that particular kind of access to occur. All of that applies less clearly to things like your IP address, your MAC address, your GPS or Wi-Fi data. And this comes out of the legacy of the phone system. Right back when we were just talking about wiretapping phones, there was a sense that, okay, the contents of your phone conversation, that should be protected, that's important for privacy, but the numbers that you're dialing, you know, that's maybe a little bit of a different thing. Maybe law enforcement can access that more easily because it's less revealing about you. And as we've seen sort of internet communications develop, I think one of the things that's really sort of profoundly different is the amount of information you can gather from this non-content metadata type of information. So there have been a couple sort of just very recent reports highlighting this. This is from a New York Times article at the very end of last year by Stuart Thompson and Charlie Warzel. And they collected a trove of location data just from a private company data broker, and it did some interesting graphics trying to show sort of how you could identify individual people out of it. One of the things that came out of that report that I think was important for a lot of people to understand is how much of this data is being collected and traded in the private sector, as opposed to by government actors. And when we're looking at the coronavirus tracking efforts now, there's much more of an effort on the part of public sector officials to start thinking about how they're going to gather that information. There is also enforcement action and concern about how private actors are using this data. This is just from a little more than a month ago. The Federal Communications Commission talking about fining cell phone carriers for not protecting users' location data. And again, I would argue a lot of this stems from the lack of clarity around who's allowed to share location data and under what circumstances, because it falls into this gray area of metadata where we're not always entirely clear on what the protections are. There are also some indications from the past couple months that I would highlight for you that some of the new location restrictions on smartphones are actually helping sort of curb how much location information users are sharing. In particular, the option to only share location data with apps that are actively running has led to a significant rollback, we think, in how much location data the application developers and operating system developers may be collecting. We think that's selected about half the time, that option, when users are given that option. The sort of legal protections around privacy for digital communications and metadata go back a long way. As I mentioned, they go back really to thinking about the telephone system. This is a very important Supreme Court ruling in the United States, Katz versus the United States, in which the US Supreme Court reversed its original opinion that your phone conversations did not have any legal privacy protections, and decides actually, yes, not only do phone conversations, not only are they covered by the Fourth Amendment protections, but they actually extend to anywhere, including in this case, a public phone booth, where a person has a reasonable expectation of privacy. And that becomes kind of the default criteria in the United States for thinking about what is protected, what does law enforcement need a warrant to access? Do you have a reasonable expectation of privacy for certain kinds of data? And as you can perhaps imagine, it's a difficult criteria to measure because our expectations of privacy are constantly evolving as technology changes, and the ability to sort of decide, okay, you have a reasonable expectation to the privacy of your location data or the privacy of your IP address or something like that, depends a lot on whose expectation we're thinking about. And it's been a very complicated issue for the courts and regulators to sort out in the many decades since this Katz ruling, as they've started to think about kind of the specific nature of the types of data that are collected by smartphones and other digital devices. Those protections are really explicitly codified in the United States in the mid-1980s with the passage of the Electronic Communications Privacy Act, or ECPA, which really very clearly lays out, look, there are going to be certain protections for the contents of your email. That's going to have the highest level of protection, which is going to be a warrant, right? If your email's been in storage for more than 180 days, then it's going to have less protections. And all of the metadata, the dialing, routing, addressing, signaling information is going to be less protected as well, right? And again, in the 1980s, location data is a very different thing. It's being collected much less in very different ways, and it's not necessarily a law that's passed with an eye to these kinds of issues, but it sets up this framework, which is in turn going to be imitated in many other countries, of saying, you know, look, the contents of your digital communications, that's like the phone conversations, that's the thing that's going to be really protected in terms of privacy. Everything else around it, all of that dialing, routing, addressing, whatever, is going to be less protected because that's less revealing, that's less private. And I think one of the really profound questions that we have to ask now when we look at, say, large-scale location data is it actually much less revealing? Is it actually much less private to know everywhere I've been over the course of a period of time than to be able to read the contents of my email or my text messages? The first sort of really big location data case that comes up to the US Supreme Court is decided in 2012. It's a case called US v. Jones. And it's a case in which a guy, Antoine Jones, is being followed by law enforcement, and they attach a little GPS device to his car to collect location data and decide, you know, is he doing illegal activities? And they find evidence that he is, and they try to use that evidence to charge him. And his lawyers come back and say, look, you can't use this evidence because it was collected without a warrant, or in this case, a warrant that had expired. And the entire Supreme Court, across very different political spectrums, all unanimously agree, yes, this was a violation of this person's privacy. This was a violation of the Fourth Amendment protections to install this little GPS device without a warrant. But what I think is really interesting and important about this case is that even though all the justices agree, they actually disagree about why it's a violation. So you get a majority opinion, which is authored by Scalia, who basically says, look, when the government went and touched his car and attached something to it to collect that location data, that was a search within the meaning of the Fourth Amendment, which means you needed to get a warrant to do it. So the invasion of privacy in this opinion is essentially the physical touching of the car. And that constitutes a Fourth Amendment violation, which is not super helpful when you think about how most location data is collected now, because a lot of it can be collected without actually going and physically attaching something to somebody's car. It can be collected in the ways that we've seen in some of the coronavirus tracking apps, through smartphones, through other types of devices. And that's where you get the minority concurring opinion, which is authored by Alito, who's kind of making fun of the majority opinion, saying they've chosen to decide this based on 18th century tort law, having to do with attaching a device to the underside of the vehicle. They're more interested in the location data itself, in the question of whether that should require a warrant, whether that is subject to any stronger protections. And they think it is, right? So this is, again, not the majority holding, but just the concurrence, saying it's actually the use of longer-term GPS monitoring that impinges on expectations of privacy. So again, you go back to that language of the reasonable expectation of privacy, and the disagreement here on the Supreme Court is, do you have a reasonable expectation of privacy for your car, that nobody's going to attach anything to it? Or do you in fact have a reasonable expectation of privacy for your location data, and a reasonable expectation that law enforcement's not just going to be able to suck up 4 weeks of everywhere you've been without a warrant? And that's really left unresolved by this ruling, because the majority just says, look, you can't go and attach things to somebody's car without a warrant. So it's not a terribly helpful ruling in terms of clarifying for future law enforcement efforts that involve location data, what is and is not allowed. We get another ruling just last year in a case called Carpenter versus US, which is dealing with exactly the same issues of whether or not law enforcement can collect location data, except in this case, they're collecting it from a mobile carrier, not from a physical device attached to a car. So the Supreme Court finally has to grapple with this question of what privacy protections are in place for location data. It's again an armed robbery situation in which cell phone location data is being used to show that this guy, Timothy Carpenter, was very near 4 of these robberies, and then being used to arrest him and charge him with these crimes. And his lawyers will argue, just as Jones's lawyers did, you're not allowed to collect this data without a warrant. This location data should be sort of part of my reasonable expectation of privacy. This is a split decision, unlike the Jones case, where you had that unanimous 9-justice agreement that there was a violation of privacy. Carpenter is going to come down to a 5-4 vote. And the majority is going to hold that, yes, there was a violation of Carpenter's privacy here when the location data was collected without his consent. It's about a week's worth of location data in this case. And the majority opinion, which is authored by the Chief Justice Roberts, essentially says, look, this is a very different kind of data from the stuff that we've let law enforcement collect in the past, like the phone numbers that people dial or their bank deposit slips. This is something that really gives a very encyclopedic knowledge, a very detailed knowledge of where somebody is, of who they are. And given that unique nature of those cell phone location records, that's actually deserving of greater protections than we've perhaps been affording it up to this point. He also addresses this question of sort of, are people voluntarily giving up their location by carrying around cell phones that they know collect that information? And the court's rule is sort of no, they're not voluntarily sharing that information because these cell phones are now such a pervasive and insistent part of daily life that it's really indispensable to participation in modern society to carry one around. And because we all kind of have to be carrying them, it's not fair to say, oh, we've just voluntarily decided to turn over to our cell phone carriers all of our location data, and therefore we have no reasonable expectation of privacy. And because of that, the Supreme Court is again going to grant some slightly stronger protections to location data, though it's not entirely clear how strong those are because they don't make any specification about whether it's legal to collect less than 7 days of location data without a warrant. They just decide, yes, for 7 days, you really do need to get a warrant in this case. And they say, well, look, we don't need to decide whether there's a limited period for which the government may obtain an individual's historical location information free from Fourth Amendment scrutiny. It's sufficient for this case, which is dealing with a 7-day period, to say you need a warrant for that. There's also, as I mentioned, a dissent in this case for justices who sign on to a dissenting opinion written by Kennedy, who says, look, why are there any greater privacy interests when we're dealing with cell site location records than anything else? A person's movements are not particularly private. Today, expectations of privacy in one's location are, if anything, even less reasonable. And their argument is basically, look, if we're doing this all on the basis of the idea of reasonable expectation of privacy, who would reasonably expect their location to be private when they're walking around everywhere with a device that's collecting all of their location information? So again, you see there's a lot of disagreement about this. This is a very, very new area. This is a ruling that comes out very recently that people are still adjusting to, that other countries are still trying to clarify what sorts of protections, if any, there are around metadata and location data in particular. And I think specifically around location data, you see a lot of attempts to say this is not quite like other metadata. You know, sure, maybe your IP address isn't being quite protected in the same way, but your location is really pretty revealing. Okay, so now I want to talk a little bit before I stop about what we've seen some different countries doing with location data and other types of personal data. This is the Alipay Health app that was been distributed in China that gives everybody a color-coded QR code that either says, you know, green, you're good to go, you're low risk, or orange or red, you can't go anywhere. We don't know exactly what different data streams feed into this. We assume location is a big part of it, possibly who else you've been near, but there's not a lot of transparency around how that's being distributed. This is from an article earlier this year about the app. Talking about this color coding system, saying the system's already in use in 200 cities, being rolled out nationwide, but the Chinese officials, the government authorities behind developing, have not explained in detail how the system classifies people. And we know that the app is also being used to report information about people's locations to law enforcement and to the government. And so you're seeing, I would say, an opportunity here to collect more location data in the name of public health that could then be used either later on or right now to do other sorts of investigations or other sorts of privacy invading work that you might not be thinking about in the moment because everybody is so focused on trying to handle the pandemic situation. And that's one of the risks that I think is really important to consider around some of these tools that are designed to help with coronavirus tracking, is sort of what are some of these unintended consequences if you're going to create an app run by the Chinese government that's also reporting location data from every cell phone that it's run on. Here are some of the emergency alerts that are being sent in South Korea to users. These I would flag for being much more specific than a lot of the other alerts we've seen in terms of demographic and personal information about the people who they reference, right? They give very specific places, very specific times, very specific age and gender information about people who have tested positive, where they've been, when they were there, and raised a lot of concerns among people in the country about sort of being outed for where they go, whether that's gay bars or short stay love hotels, and feeling like that information is being broadcast very aggressively, and perhaps, you know, with less anonymity protecting measures than would be possible if we started trying to strip some of these alerts down to the bare minimum information that would alert people who might have been exposed that they should consider being tested or consider self-isolating. In Russia, we've seen reports of using facial recognition technology to enforce quarantine. This would be an approach, perhaps, if you were concerned that people were going to start leaving their cell phones at home because they knew that was being used. It's not clear sort of either how well this works or how widely it's been deployed, but I would say it's again an example of sort of perhaps taking advantage of the crisis a little bit to deploy even more widely technologies that are still very much in their infancy, where we still don't have a strong sense of what the privacy and security protection should be, and where it's again not clear that it's necessary to go this far in terms of how much information needs to be collected and how much needs to be revealed about people's movements and activities to serve the public health need that's trying to be met here. Israel has also decided in the past few weeks to access a collection of cell phone location data that was initially collected for use in counterterrorism and is now going to be repurposed to help track the spread of coronavirus. I would say this is an example of a country that has tried to put some restrictions in place. They've passed a law that basically says it can be used for 30 days for this purpose. Now, of course, that could be extended because, as we all know, all of these time windows are sort of a moving target right now, but just the effort to put in place some time restrictions, I would say, shows a little bit of attention to this question of what's going to happen when all of this is over. Will all of our location data still be in the hands of governments? Will they be able to do whatever they want with it? Or will there be some baked-in privacy protections to think about how to limit how widely this data is being used and shared? In the UK, we've seen some efforts, particularly in partnership with BT, to try and map phone movements. And here you'll start to see sort of the shift to private industry-led efforts, where instead of having a government agency be in charge of trying to collect everybody's location data and send out alerts, you're looking at countries that are more interested in having the entities who already hold this data be in charge of aggregating it and putting out heat maps or alerts or anything along those lines. That's also going to be true in the United States, where the government has been talking to companies like Google that hold a lot of location data about whether it's possible to do any kind of aggregate anonymized analysis of some of that data and show where it seems to be most prevalent or where the highest risk areas are, and allow people to sort of get some information that way without revealing too much or invading people's privacy too aggressively. We've also seen this in Singapore, where there's a Bluetooth app that's being used that people can download voluntarily to alert them when they're in close contact with people, because Bluetooth is really useful for that sort of less than 6 feet distance that we're also attuned to at the moment, and trying to find sort of other compromises for how can we alert people who want this information and are willing to share a little bit of their own information in return without necessarily going all the way to rolling back all of the fairly hard-won privacy protections around location data. Okay, I'm going to stop there. I've sort of run through a bunch of different countries and a little bit of law. Happy to take questions if you have any. I'm sure there are other speakers and other things that are going on today for all of you.
Well, thank you so much for that really, really interesting talk. Yeah, interesting to see how those different lines of legal reasoning in the US Supreme Court lend different interpretations, particularly the reasonable presumption of privacy. Because I mean, yes, in a world where everyone is constantly vaguely aware they're being monitored through their phone, but also actively live streaming themselves or using their face to get into places. I think it's kind of gives the lie to that expectation. One of the things that came out in an earlier talk we had with Professor Ko from Seoul National University. He was firstly talking about the Korean instance. He went into some interesting kind of details about the, I guess, that very, very high level architecture of the way the information will flow between municipal authorities and telecoms businesses before those alerts are pushed out. He was talking about the kind of choices on offer to telecoms providers as to how and why and whether or not they collaborate with governments in providing this information. I mean, the view he had was this ultimately is very dependent upon market dynamics within particular states. So he said that in most states, telecoms are usually an oligopoly of some sort, very heavily regulated, so they will just have to do what the government says. Would you agree with that particular statement about
in many states that's certainly true. I would say, you know, the carriers are not the only companies of interest right now, right? You look at a company like Google with Google Maps, and there's also a complicated calculus there around what they can do with their location data and sort of whether there are governments that are going to partner with them. But yeah, I think it's fair to say that many of the telecom companies in many countries around the world work very closely with governments and don't have a whole lot of choice about that.
Mm-hmm. Do you see, what would you say are the single most alarming trends that you see out of all of those to come out of this crisis?
I think the most alarming trends are the use of facial recognition in this context, where we're really sort of not at all clear that we have the technology at a point where it can even be especially useful or accurate for these kinds of purposes, and the use of sort of broadcasting very personal information based on location in the name of alerting people who may be at risk, right? The use of sort of sending such specific information that it's very easy for me to reverse engineer, oh, I know exactly who that is, the 28-year-old who works at this place and was in this bar and was walking home at this time. I think those are the things that seem most alarming right now.
One of the things Professor Yu mentioned in his talk at the beginning of yesterday was the capacity of the measures that come in place now to become normalized. Either become normalized as a set of practices, or in a kind of starker way to actually, for, you know, let's say a state of emergency to just roll on. I mean, there have been a few countries around the world that have been in states of emergency technically for many years, starting with one crisis or another. Would you identify particular risk of that at the moment, based on as you've seen the narrative on data collection developing in certain states, or do you think we might?
Yeah, I think there's a real risk around location data that we're just going to sort of end up in a state where governments feel that's something we obviously need to have access to at all times, in all ways, in the event of any sort of crisis or crime, right? I mean, it's of course a very useful kind of information for government and law enforcement in particular. And it's hard for me, I think it's just in general hard for governments, once they have access to some kind of information, to give that up. And I think you're right, the obvious analogy for sort of thinking about digital surveillance is probably September 11th. And in the United States, we saw a lot of changes, we now know, in how that kind of surveillance was being done of communications, both overseas and in the US. We didn't know this until much later because of the Snowden leaks, but there's certainly the sense of, you know, in a moment of crisis, everybody mobilizes to try and make changes that they feel will help. And those changes can last many, many years. And I do think there's a risk right now that, again, I would say mostly around location data, there's going to be a sense of there just needs to be easier, faster, more comprehensive access to that for governments around the world.
Now, I can't help but note on that note that behind you is a poster saying the age of Napoleon, who is, of course, a kind of almost paradigmatic example of an authoritarian leader rising in a period of instability and crisis, and then, I guess, reconsolidating a strong centralized state with bureaucratic and historical patterns that have carried on in his state and then its imitators for the next several centuries. I mean, do you see, we've had a kind of discourse between some of the speakers on the stage today about the capacity of states to become more authoritarian, for there to be a move away from multinational institutions. I've been very struck personally in the situation that's been evolving on the incredible speed, and I suppose in fairness there has just been speed across all things, but the incredible speed of the elite consensus forming that there needs to be more surveillance. It's only really actually interestingly, at least in the British press, right-wing voices who map heavily, although not exclusively, onto being harder Brexiteers, interestingly enough, on a sort of cultural level, who are speaking out, as far I can see at this stage of the crisis, against well, so much of the suppression of civil liberties and surveillance. If we look at this more on a kind of cultural level, you know, and talking back to that point you made earlier about the expectation of privacy, what factors do you think tend to make people accept certain, you know, new normals about their data, that certain kind of legal cultural frameworks? Is there anything you can speak to around that?
I think the fear is the main factor, right? That when people are afraid, as they are right now, there's definitely a strong shift in how much they're willing to give access to personal information about themselves, partly because they want some of that information about the people who live all around them, and they want everybody else to be subject to the same kind of monitoring and quarantine restrictions and all of that. I think, you know, that's the biggest thing you're seeing right now. It's the biggest thing we saw after September 11th was the sense of, you know, of course, I will let the government know where I am at all times if it means that we can get a hold on this pandemic and fewer people will die and we can go back to living normal lives. And I think that's a very understandable instinct, right? To sort of feel like if this will help, then let's do it, because things are so bad and so scary right now. I think the larger question, and one we certainly haven't answered yet, is, first of all, will this help? And second of all, which parts of it are needed to help, right? And it's one of the things that I'm hoping sort of in the aftermath of everything we'll be able to study and understand more clearly. Does it help to have aggregate anonymized data about where people are moving? Does it help to have sort of more granular specific information? Can we actually sort of design any natural experiments or say anything about the effectiveness of any of these measures? And I would say, you know, I think this is true of a whole bunch of things that we're a little bit unsure how much they help right now. We've seen all of the guidance shifting on whether or not people should be wearing masks just in the past few weeks, right? And it's the same thing, I think, with tracking location data, where we would like to believe we can make a really big difference, and maybe we can, but we're also all sort of making it up as we go along, and we don't know how much of a difference is there between the effectiveness of what Singapore is doing, of what South Korea is doing, of what China is doing, of what the United States is doing. And until we sort of have some ways to assess that, we're all just sort of scared and trying to invent things we think might help.
Well, and I suppose, you know, as someone who did at least one module of political history, that does kind of does very much recall Hobbes' model of the Leviathan, right? I mean, this community in fear and terror, creating this useful monster, but a monster nevertheless. Yes, I find it all quite alarming. Now, I note that we have at least 3 individuals who, if they're on, might have some particular views. Do we have any comments from Professor Coe, who I see has joined, or perhaps Ben Hawes? I know we have your session starting in 20 minutes, but if there's anything you wanted to flag before we close this session, or perhaps Professor Yu? It's quite all right if not.
If I may, first of all, Josephine, thank you for joining us with such a short notice. And I really enjoyed listening your talk. You know, one thing that I was thinking is that, you know, I'm working with a team trying to build an app that is providing quite granular, like almost like a Chinese app, except that it is individual, privacy preserving and consent based. And, you know, when you read all these reports, what companies say that they can do at a very aggregate level, it seems to be quite clear that engineering technique and sort of network technique that we can use and the data at a very granular level is already readily available. What is stopping them from using it is really the bad press that they worry about, but it takes just one instance that someone gets a really bad press, and then it becomes normalized, and then it becomes normal, right? Because that has been the case with Facebook, that has been the case with many political discourses in this country over the last few years. Do you think that while we're working very hard to make it work without compromising privacy, but it takes just one bad actor just forging forward? Let's say Facebook says, in the name of public safety, we're going to do this, and then there will be outrage, but then there will be second and then third and fourth app because Facebook took the most hit, or Google took the most hit, or some unknown the tracking specialist company who's collecting all the location data, and then this is the lost battle. I don't know, what do you think? I mean, you looking at the history of this kind of changes on the public opinion and perception and larger political discourse. Is there any way that we could, other than being first, so that demonstrate that you can do it without compromising? And I think that probably will be the most important thing that we could do at the moment. And maybe that's why it is motivating to have this kind of hackathon. I don't know. I just wanted to hear your view on that.
Yeah, I think that's a really great point, that there's, a lot of people thinking right now and a lot of companies thinking right now about what they're going to do, and some of them are going to do it better and some of them are going to do it worse. And it's not necessarily that the ones who do it better are the ones who are going to be used most widely or reported on most aggressively. I think what I would say about that is the work that you're doing is still really important work, even if one of the big tech companies is going to do something less privacy protecting first. Not because there's necessarily going to be a huge backlash to what that company does or what those companies do, but because I think one of the things we see if we look back at the past couple decades is that there are eventually sort of reckonings around privacy and security. They often take a while, and probably, in the time scale in which things are happening right now, I cannot promise that everybody is going to be as attentive to some of these issues as we might want them to be. But over time, as some of this falls out and more is understood about what worked and what kind of information was needed and what kinds of privacy rules were bent to get where we got, I do think there's going to be an appetite for the kinds of solutions that you're working on. And I hope at least that we're going to use this as an opportunity to think more seriously about what the rules should be in crisis for next time, which is, I would hope the best thing we could take out of this is some sense of, okay, the next time there's a situation where it seems like it might be helpful to know where everybody is and where they're moving, what kinds of tools do we want to have, what kinds of rules do we want to put in place? And that's where I think tools like the ones you're building would be really useful and really important.
Thank you.
Thanks.
Well, guys, it's been a really fascinating conversation. I have certainly learned a lot through it, and it's very interesting hearing those slides and the conversation that we had stemming from it. First of all, thank you so much for joining us. We're now going to take a very quick break before our next talk, which is on coronavirus and the smart city, given by Ben Hawes, who's here. Hello, Ben. Waving. So yes, we'll take a 15-minute break, and then we'll talk about the smart cities and how that'll impact on data collection. In particular, of course, location data collection. First of all, if you're interested in joining that talk, if you have time, I'd strongly recommend it because it will have a strong focus on location data.
Fantastic. Thank you so much.
Thank you so much. I'm now going to switch off the recording, and did I pause the recording?